Title of the case is People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here on as sui juris impropria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land.
Free woman, you say? Well, that's going to change by the end of this video.
I'm here under fraud, menace, and duress. I am the private woman, Rosalind Ray
All right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime an autograph is to be done in a certain manner that I have here, or it's forgery. Could you do this for the judge, please? That's my name. Thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan beneficiary with quick bail bonds. All right, now we've got another issue. This is a felony charge. The first one is. The second one is under the motor vehicle code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it.
Free woman, you say? Yeah, let's see how that holds up by the end of this video.
Mr. Marvin, is there a plea offer here?
There is, and I'll tell you about that. But I wanted to mention that this is, I believe, the third time we've sat down, and so this is dragged out a bit, but only because she's not represented, and in these 3 separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life, that she's honestly trying to understand, but I think that partly to assist her, I've kind of hatched this plan and I've offered that. I have the feeling she's going to take it today, but if not, I've got my officer and we're ready for a prelim.
Let's be honest. Sovereign citizens only take advice from other sovereign citizens. Birds of a feather fly straight into propellers together. Now the prosecutor is about to lay out the plea offer, and I'm not exaggerating when I say this might be one of the sweetest deals I've ever heard, and yet, she still turns it down, because of course she does.
He's offering to reduce the driving suspended charge. And he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the
All right,
charges.
Mr.
against
Marvin,
me.
let's just do a prelim. I'm not gonna tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm gonna have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What'd you say about the,
It's a benefit. And
no, before that about the license?
he's dismissing it. And it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it. And that's a benefit. He is offering to reduce the felony charge to a misdemeanor. And that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's
Explain
just
it.
put
I'm not
on a
playing
prelim.
games. I'm serious.
You are
about
playing
testimony.
games. And first of all, you
I'm trying
don't.
to advance to
All right,
what I'm
stop.
here.
You don't
for.
interrupt the judge, whether you're a flat earther or
I'm
not.
not flat earth. So.
All right.
So let me break down just how sweet this offer really is. First, the prosecutor is willing to reduce the felony to a misdemeanor. Second, the misdemeanor she was already charged with? Dismissed entirely. Finally, if she stays out of trouble for the next 6 months, that reduced felony gets wiped from her record. In other words, she has the chance to turn a felony and a misdemeanor into basically nothing. A complete nothing burger. I'm not gonna lie, this deal is as good as it gets. Honestly, it's way too lenient if you ask me. And Judge Middleton seems to agree.
All this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So do you wish to represent yourself, or would you like me to get an attorney to assist you with this?
It's my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office
To do what?
to if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well, do
And
you
I-
want me to appoint an attorney for you? Would you like to represent yourself?
So may I ask what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case.
Might as well be a flat earther. I've covered a lot of different types of stupid people on this channel, but only flat earthers and sovereign citizens can claim that their chromosomal deficiency somehow comes from a delusion. In other words, they've managed to blame reality itself for their own nonsense.
Criminal case means you could go to jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants the court 2 types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these 2 jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution. And I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed. And I would like it in writing, please.
The fact that you even had criminal jurisdiction to ask that question should be all the evidence you need to realize you're completely out of your league, Karen. But hey, sometimes you've got to let a flat earther walk off a cliff to prove gravity exists, and sometimes you just have to let a sovereign citizen go to jail to prove jurisdiction.
Thank you. It's not civil procedure, it's criminal procedure. And the defendant doesn't come up and show, court, tell me why I get to do this. You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here and the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge, of attempted resisting and obstructing a police officer. He offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is very generous based on the police report, bond information that I came with the file. What would you like to do here today? Do you wish to represent yourself?
Thank you. I do. I know I can peer for myself. I'm competent and I am confident. Okay,
All right.
so
The next question is, are you
Please.
willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to peer for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All
under
right, stop.
admiralty or military
Stop.
tribunal venue.
Stop. You went through this before.
I
This
know,
is not civil
it's the
procedure.
Sixth Amendment grants me the right to know the jurisdiction being applied,
And I told you what it was.
and it gives you the duty.
All right, stop.
How nice of you to say please, especially after vomiting your nonsense down our ears without warning us first. Now, you asked for a copy of the Michigan Civil Rules of Procedure in writing. Sure, you can find them online in Chapter 2 of the Michigan Court Rules, but here's the kicker, they won't help you at all. Why? Because this isn't a civil case. We're dealing with a criminal case, and the rules for criminal procedure are in Chapter 6 of the same publication, so while you were busy demanding rules that don't even apply, the rules that actually matter were right there all along.
If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail. And
Objection, please.
all right, please.
Please.
We're going to
sir,
talk
may
about
I-
this
the
tomorrow
contempt.
at 3 o'clock. I find that you're in contempt.
I
You're
do
going
not
to
wish to
jail
be
right
held in
now,
contempt,
and we
sir.
will. Well, you have been.
I'm
This
simply
matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
So you can think about
And
it
we can go
overnight in
forward
jail.
with this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3 o'clock. And you will be more respectful to the court.
I
You
can
will speak-
provide the
You will not interrupt the
citations.
court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you. Do
go
you wanna
with the
continue?
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We
arguing.
will address this tomorrow at 3 o'clock.
Yeah, I don't know what's going on, and I don't think this was a fair trial,
We haven't had a trial yet.
a fair preliminary.
We didn't even get there yet.
I'll be more than happy to. She's going into custody for contempt.
Okay, let's go this way.
If I were you, I'd zip it, Karen. Judge Middleton isn't playing your games, and your inability to stay quiet is about to cost you a night in jail.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And I think it was just a misunderstanding of how to, for her to be able to pronounce that. But
Well, I told her to stop and she didn't stop, and she doesn't know what she's doing. She needs a lawyer, and she's gonna contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock, and to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record, and all she wants to do is argue about admiralty fees.
What she wants to do is argue about nothing, really, Judge Middleton. Cold-blooded. And honestly, that's exactly how every judge should handle these morons. Alright guys, that's the end of today's video. Fun fact, she's actually being released from jail at the exact same time this video goes live. Timing is everything. If you liked the video, leave a like. If you didn't, leave a dislike. Either way, drop a comment below and make sure you're subscribed with notifications, because this saga isn't over yet.